May it please the court. Ellis, initials SJ, appearing for the plaintiff Southern Forest Alliance in this matter. Your Honours, this case does not seek to determine whether the Commonwealth has legislative power to protect World Heritage forests. Instead, the central question before the court today asks whether the Commonwealth, in the name of protecting those forests, may place political protest under executive permission and make it a criminal offence to criticise climate science and government policy. The plaintiff respectfully challenges the constitutional validity of the Climate Integrity and World Heritage Protection Act. This challenge is not directed in any substantial way to Section 10, the plaintiff accepting that a prohibition on industrial logging in declared climate protection zones sits comfortably within the Commonwealth's external affairs power under Section 51, subsection 29 of the Constitution. Section 15, however, does not merely protect land from physical harm. Instead, it regulates protest, it regulates public discourse, and it does so in relation to political communication about government policy, environmental regulation, and Australia's participation in the Global Climate Preservation Convention. The Minister's refusal of the plaintiff's protest application, having been made under the impugned provision, should be treated as having no valid legal foundation. Your Honours, today the plaintiff makes three submissions. First, Section 15 is not a valid implementation of the GCPC under the External Affairs Power because it is not reasonably capable of being considered appropriate and adapted to implementing the treaty. Second, even if Section 15 is supported by a head of power, it impermissibly burdens political communication. Third, the proper constitutional consequence is partial invalidity, with Section 15 severed and relief granted against Commonwealth officers. Your Honours, the plaintiff's first submission concerns the Commonwealth's external affairs power. It is accepted by both parties that under Section 51, subsection 29, the Commonwealth may legislate to give effect to a genuine international treaty obligation. However, as this court confirmed in Victoria and Commonwealth, the existence of a treaty does not confer plenary legislative power over its subject matter. The law must be reasonably capable of being considered appropriate and adapted to the treaty obligation, and the means chosen must bear a sufficient relationship to that obligation. The plaintiff accepts, for present purposes, that Section 10 satisfies this test and does not wish to challenge its validity. However, Section 15 stands in an entirely different constitutional position. Section 15, subsection 1A, conditions the right to protest within a climate protection zone upon Commonwealth approval. Subsection 1B goes even further, criminalising public statements that undermine or contradict the scientific basis of climate change, including criticism of government policy, environmental regulation, and Australia's participation in international agreements. The Commonwealth has submitted that effective treaty compliance permits it to regulate protest and misinformation, but this submission overlooks a critical constitutional requirement. His Honour Justice Dean observed in Commonwealth and Tasmania that a treaty directed to preventing the introduction of a foreign sheep disease could not support a law requiring the slaughter of all sheep in Australia. Although such a law would bear some connection to the treaty objective, the connection would be so extreme and disproportionate that it could not properly be characterised as implementing the treaty. The GCPC requires environmental protection. And just as the slaughter of Australia's sheep would be an extravagant means of preventing a hypothetical disease, the silencing of political speech by Australian citizens is an extravagant means of protecting World Heritage forests. That is not implementation. It is the control of political discourse. The plaintiff respectfully submits that the impugned provision does not constitute a valid implementation of the Convention. Rather, the practical and legal operation of Section 15 reveals that it is a law with respect to the control of political communication and therefore lacks a sufficient nexus to the treaty, falling outside the scope of Section 51, subsection 29 of the Constitution. Your Honours, should the court accept the plaintiff's submission regarding the external affairs power, I turn now to the plaintiff's second submission, that even if the court accepts Section 15 as having sufficient connection to the external affairs constitutional power, the impugned section should nevertheless be invalid, as it impermissibly burdens the implied freedom of political communication. As this court recognised in Brown and Tasmania, on-site environmental protest is a significant form of political communication within Australia's constitutional system and is considered to be a burden where a law imposes a real limitation upon the freedom or creates a chilling effect upon participation in political debate. Section 15, subsection 1A, directly regulates the time, place, and manner of political protest. By requiring advance ministerial approval before such a protest may occur, subsection 1A places political assembly under executive control. But subsection 1B imposes an even more direct burden. It does not simply affect political communication incidentally, it criminalizes the content of political communication itself. It prohibits statements that undermine or contradict climate science. Speech supporting the Commonwealth's stance is permitted, while speech that challenges their position is not. The provision, therefore, burdens political communication in its clearest and most constitutionally problematic form. The plaintiff accepts the objectives outlined in the Commonwealth submissions do in fact represent a legitimate purpose, and thus they do not intend to challenge this notion. Rather, the plaintiff submits that the law nevertheless fails to justify this burden upon application of the structured proportionality test, which was affirmed in both McCloy and Brown. In assessing the law's suitability, the plaintiff accepts the Commonwealth's submission that Section 15 is likely to bear a rational connection to its stated purpose. It is rational to presume that regulating protest activity within protected zones may assist the Commonwealth in achieving environmental protection and may advance its conception of effective treaty implementation. However, if I may advance to the necessity stage of the structured proportionality inquiry, the plaintiff submits that Section 15 fails this test. A law is not necessary if there exists an obvious and compelling means to achieve that same purpose that is reasonably available. Standard trespass laws and public order offences provide an obvious and compelling alternative to forest protection. Environmental protection legislation already regulates environmental damage. Targeted exclusion zones, content neutral permit conditions, and ordinary policing powers can address genuine safety concerns without deploying the blunt instrument of criminalising political speech. This court has already accepted that protecting forestry operations was a legitimate objective in Brown and Tasmania. Nevertheless, the legislation still failed as less restrictive alternatives already existed, including ordinary criminal laws and existing forestry regulations. This same reasoning applies here, albeit stronger. Section 10 of the Act already prohibits industrial logging within climate protection zones. The Commonwealth has therefore already enacted the primary environmental protection measure required to protect these forests. The inclusion of Section 15 is fundamentally different, as it does not target environmental harm, it targets political communication. This problem is further illustrated in Section 15, subsection 2, which permits the Commonwealth to assess whether a protest, or the message it conveys, is inconsistent with Australia's climate obligations, placing political communication dangerously close to executive permission. As for subsection 1b, the constitutional defect is even clearer. The Commonwealth can protect forests, maintain safety, and comply with treaty obligations without criminalising criticism of climate science or government policy. The existence of those obvious and compelling alternatives means the provision cannot satisfy the necessity requirement. In anticipation of my learned friend's reliance on the case of Liberty Works, the Commonwealth will argue that this law is adequate in its balance. Although the plaintiff accepts that the public interest pursued by the legislation are significant, they contest the adequacy of the law on the grounds that the burden imposed by Section 15 is severe. Subsection 1A burdens protest at the very location where the communication carries its greatest force and visibility. 1B goes further still. As this court recognised in Clubb and Edwards, laws that burden political communication require careful scrutiny. A law that burdens one side of a political debate presents a far more serious constitutional concern than a law regulating only the time, place, or manner of communication. The vice of Section 15, subsection 1b is not merely that it burdens communication, it criminalises one side of a political debate concerning climate science, environmental regulation, economic policy, and Australia's participation in international agreements. It burdens one viewpoint while leaving the opposing viewpoint untouched. The benefit of administrative convenience is manifestly outweighed by the chilling effect this has on the Australian electorate. The Commonwealth may regard the plaintiff's views as misguided, unpopular, or scientifically inaccurate, but the Constitution does not require political debate to be correct. The provision therefore fails the test of adequacy and cannot survive constitutional scrutiny. Your Honours, the Commonwealth's submission has heavily relied upon Farm Transparency International Limited and New South Wales in an attempt to refute the plaintiff's arguments. It has been submitted that the implied freedom does not confer a right to trespass, and that SFA has no constitutional entitlement to enter a protected zone in order to communicate its political message. However, the plaintiff argues that the precedent of farm transparency does not pertain to this matter at hand. There, the High Court upheld provisions prohibiting the publication of visual records obtained through trespass. The burden on political communication was justified because the impugned communication depended upon conduct that was already independently unlawful. But the case before the court today is not about a right to trespass. Subsection 1b does not target entry, damage, or obstruction. It targets the content of political speech. The constitutional burden therefore arises not because the communication depends upon unlawful conduct, but because the statute selects particular political viewpoints for legal disadvantage. Unlike farm transparency, where the communication depended upon independently unlawful conduct, the plaintiff simply utilised the statutory approval process, seeking to protest through the very mechanism the Parliament itself created, which the executive then refused by reference to criteria including treaty compliance. The burden, therefore, arises from executive control over political communication, not from the enforcement of ordinary property rights. Farm transparency does not provide the Commonwealth with a blanket constitutional shield. Were the plaintiff arguing the right to physical access on protected land, farm transparency may have assisted the Commonwealth. It does not, however, answer the plaintiff's actual challenge, nor does it transform a reasonable restriction on property access into a valid law used as a Trojan horse for the suppression of political dissent. I turn now to the third and final submission, the constitutional consequences should the court accept the plaintiff's primary submissions regarding the invalidity of Section 15. Your Honours, the plaintiff does not ask the court to strike down the Act as a whole. Section 10 can operate independently. It regulates industrial logging and is directed to the physical protection of World Heritage forests. Thus, it should remain. The plaintiff instead submits that Section 15 may be cleanly severed from the Act. Drawing upon the principles of Victoria and Commonwealth, Section 15A of the Acts Interpretation Act supports severance because Section 10 and Section 15 are separately expressed and perform unique functions. Striking down Section 15 does not alter the legal operation of Section 10 in any respect. It remains a complete workable and effective provision, continuing to prohibit industrial logging exactly as Parliament intended. The plaintiff's alternative submission is that, at a minimum, subsection 1b must be severed. It cannot be read down in any meaningful way. Reading it down to exclude political communication would remove the very subject matter that Parliament expressly chose to regulate. That would not be construction, it would be judicial redrafting. The plaintiff turns finally to the matters of relief. If Section 15 is invalid, the minister's decision was made without lawful authority and in excess of constitutional power. The minister is an officer of the Commonwealth, and Section 75, subsection 5 of the Constitution gives this court entrenched jurisdiction to restrain Commonwealth officers from acting beyond their federal power. Accordingly, the plaintiff seeks a constitutional writ of prohibition and injunctive relief under subsection 5, restraining the minister and any relevant Commonwealth officers from continuing to rely upon the refusal of the plaintiff's protest application and remedy the consequences of acts done in excess of federal power. The plaintiff further seeks a declaration that Section 15, or at least subsection 1b, is invalid, sought ancillary to the constitutional relief and pursuant to the court's jurisdiction and remedial power. Your Honours, the line the plaintiff asks this court to draw is a modest one. The Commonwealth may protect World Heritage forests. It may regulate obstruction, environmental damage, and genuine safety risks. But it may not criminalise political disagreement about climate science, government policy, or Australia's participation in an international treaty. Section 10 protects the forest. Section 15 regulates political communication. This is where the Climate Integrity Act crosses that constitutional line. May it please the court.